So, welcome everyone. Welcome to the last installment of this series for this year. We will be starting up again in January. But welcome to our current installment of this wonderful series with the equally wonderful Meg Mott, where we examine the amendments in consecutive order. So tonight we'll be talking about the Sixth Amendment, and I also have a news flash for you. If you haven't heard already, something very exciting has happened, which is that this series won the BCTV Producer Award for Series of the Year, and yay, exactly. So, and rightfully so, right? Because it's amazing. But we get to be here live and participate. And I also want to thank the Friends of Brooks Memorial Library who make this series possible. So let's have a round of applause for them as well. We have other fabulous events coming up this month, so please do stop by the table on your way out and pick up some information about those upcoming events. But now, here's Meg.
All right. Thank you, everybody, for coming out tonight on this. This is the final in the series of the Debating Our Rights for this year, but we will pick up with the Seventh Amendment, another exciting amendment, in January 2020, January 15th. It's not the second Wednesday because in January, the second Wednesday is the first Wednesday as far as the Vermont Council's on Vermont Humanities Council is. So if you follow my drift, we will be doing the third Wednesday in January with the Seventh Amendment. As I said, another one that's very close to my heart because it has to do with juries. As Starr mentioned, I'm very, very honored to have received this award for the Debating Our Rights series. And it wouldn't happen unless Janice Shalou and M. Richards, who usually isn't around here. My partner Allison Mott is working second fiddle, but Janice and M together are something called For the Record Video Production, and they are the ones who produce this series, which you can find on BCTV. So if you missed any of the earlier amendments, you can go online and find out. So anyway, thank you very much, Janice and M, because they really made this happen. Janice is telling me something else.
Meg also won, it was a double series. She won not only for Debating Our Rights, but also the Good Clash series.
Oh, yes, right. Good Clash?
Disagreement.
Yeah, okay. Art of Productive Disagreement. And that's also up online, BCTV. So if you're looking for a good clash, that's where you should go. Some of you I know are part of that, those exciting series as well. So, but tonight we're going to talk about the Sixth Amendment, and a lot of the Sixth Amendment is about the juries. So I'm curious before we get started, and do feel free to be very honest. We want people to serve on juries, but we also know human beings are not always so inclined, especially if it's a certain time of the year, or if you have something else to do, or if you just really think, oh my gosh, I know what that case is and I don't want to do it. So if you answer any of these questions, we're not going to necessarily think that you feel that way, especially when I flip over to reasons not to serve on a jury. But I want to get first, like, why are you all, if you have served on a jury, or hypothetically your neighbor has served on a jury, why do you want to serve on a jury? You can shout it out. Yes?
Well, I think in the 8th grade I had a wonderful social studies teacher, and she made it an absolute duty to do.
So your 8th grade teacher said when you get old enough, or were they sending 8th graders to in your town into jury? No, it was like when you had a chance, you wanted to do it. Can you tell us your name? Jane, thank you. So it was a civic duty. Like, why, Jane? I have to put a little more pressure on you.
Well, I have served on a jury, and I think it's a good idea. I think if we abdicate the responsibility, we end up with very limited jury pool.
Yeah. So don't abdicate responsibility. Take it up. And if we all do it, it's going to be better. You
Absolutely.
Absolutely. Okay, great. Thanks. Any other reasons to serve on a jury? Yes, in the back.
It's fascinating to see the process unfold.
fascinating process. Do you want to add anything now that they've given you the mic?
Well, you get to see how the defendant is treated, you know, and what the attorneys are up to with their computers, and it's...
Yeah, you get to watch attorneys in action. And can you tell us your name?
Martha.
Martha. So Jane, Martha. Did you notice anything about those attorneys, Martha? Like, there was anything in particular? You said they were using their computers. Was there anything else?
It was very different from TV.
Ah,
It's much more low-keyed.
Yeah. Yeah, so in a sense, when you're up close, you really get to see the reality of a trial, as opposed to Law and Order or what's happening. Yeah, great. Other reasons, like why is it good to serve on a jury? Yes, oh good. Can we get the mic to Sharon?
When I left the jury room, I was so, it reaffirmed for me the value of that system and the knowledge that, wow, this really works. At least it did in that jury that I was on.
Wow. So just have a sense that it really does work. For you, Sharon, you watch the whole process, because a lot of times people watch the process, or they think about the process, and they say, this is terrible, the system is broken. You know, and there's reasons to be suspicious of the criminal justice system, but when you actually get inside the courtroom, you saw it really works.
It really works, and I've been on several juries, and I would say that about all the ones that I was on.
Wow, but they all worked.
They all worked.
Yeah.
One of them was kind of like 12 Angry Men.
Yeah.
Where we had some people that we needed to talk to, and it was very affirming of our system.
Wow, great, affirming. So even though it started out as 12 Angry Men, right, which is usually a very contentious situation, if you remember Henry Fonda, that version, but it's also been performed around here a lot of times, that when you're in the midst of it, you begin to watch how maybe human beings aren't so disastrous after all. Maybe. Any other, like, reasons to serve on a jury? And then I'm going to switch to the other side. Yes, Steve.
If we didn't serve on juries, judges would have all the power.
Yes, yes. Keep judges in their place. No insult to the judges in the room. No, but that's part of it. That's how the system is designed, for exactly what Steve said. Unless there's another, I'm going to move us along to the other side, unless there's something somebody wants to add of reasons to serve on a jury. This is all very beautiful. No? Okay. Reasons to not serve on a jury. Again, I'm not going to assume that you're speaking for yourself, right? Eric?
Juries in the United States have typically been riddled. Juries in the United States have typically been riddled with racial bias, in particular, but gender bias, class bias. It's been shown to be biased. So.
Racial bias, gender bias. Did you say class?
Class, just all of the isms.
Okay, great. Something else, reasons not to serve. Jackie?
Having little kids at home can logistically
Yes,
make it pretty
exactly.
hard.
Little kids at home. Yeah, because you go into a jury, you don't know when you're going to get out. You could be on for a long, long time. Yeah, that's a serious problem. Other reasons not to serve on a jury. Steve, I love how you can be both sides. Yes.
I'm not sure it answers the question exactly, but I was excluded from a jury because I didn't believe in the death penalty.
Uh-huh. So, and this gets at another piece about the bias. Do you want to elaborate on that? Like, why was it that you were excused and you said because about the death penalty, but why does that make you feel bad about
It was
juries?
a case in which the death penalty might have been required.
Uh-huh.
And they asked everybody in the jury pool, is that okay with you?
Mm-hmm.
And I said no. And so they kicked me out.
So is it okay, Steve? I'm going to write down maybe slanted towards one side. And in this case, it sounds like the prosecutor said, we don't want you on this jury.
Well, no, I mean, I think it was the judge said if you're not able to, follow the law in this case.
Mm-hmm. I see. Okay. And I said maybe slanted towards a certain viewpoint per statute. Maybe part of the problem. Cool. Other reasons why? Oh, I think Judy. Did you have your hand up? Sandy. I keep wanting to call you Judy. I'm sorry, Sandy.
Well, I don't know if it's related, but in a big city, they say jury duty parking over here. So my vehicle was smashed and broken into because they know you're stuck in all day.
Wow. So wait a minute. Okay.
Never
Sandy.
park where they say jury duty parking.
Really?
Don't
Why?
do it.
Because are you suggesting, Sandy, that society at large hates jurors? Is that what you're saying? That you're taking
It's
your...
possible. In the case, she was a nasty-looking, mean girl, I'll tell you.
Wow. So jurors, and Sandy, you are getting at something, that jurors risk social censure. Right? I mean, if you're in a jury on a high-profile case, it can be a little tough. You're going to be put in the hot seat. Any other reasons? Yes, Eric.
Jurors typically don't have like a really basic understanding. Jurors typically don't have a basic understanding of the law and of forensic science, which I think you could have pros and cons for both, but I think it's really easy for prosecutors especially to manipulate juries by giving them a lot of false evidence or false forensic science.
Wow. Easily manipulated. That's a big one. Okay. Excellent. I'm going to get us started then. We found out what are the reasons to be on a jury. We found out the reasons why maybe we don't want to be on a jury. But it is one of those constitutional rights. So would somebody be willing to read the Sixth Amendment? Sharon, can you read it from there? Sharon in the green. Look at,
I'm bringing the mic.
oh, look, and do you carry a Constitution with you, Sharon?
Today.
Today you're
Today.
carrying a Constitution with you?
Just today.
Oh, that's too beautiful. Okay, that's great. Because really, everybody don't leave home without your Constitution. So Sharon, can you
You never
read
know
to us?
when you're going to have to read it.
Exactly. There we go.
The Sixth Amendment, rights to a fair trial. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him or her, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Right. So like a lot of the other amendments that we've talked about in this series, this has everything to do with the criminal prosecution. The Fifth Amendment also had a lot of rights for the accused. This one has got so many parts in it, and it has a lot to do with the procedure that, and maybe you saw this, Jane, in your high school civics class. It oftentimes gets reduced to this, that it's about due process and rights. It preserves procedural due process. There are 6 provisions: the right to a speedy and public trial, right to a jury trial in the same locale. Notice how they changed it in civics. It's not state and district, it's locale. Anybody know which is right? I mean, why, like, locale is a little problematic. Anybody know why? Is that true? Sometimes they move trials, absolutely. If you're charged for a really heinous crime in a town and everybody knows all the details, you do not want to be tried in that town. So the Sixth Amendment says state or district as defined by law, but sometimes people get a little confused and they want to make it sharper and shorter. So it's always good to double check, but this is what I got off the interweb from a high school civics class. The right to be informed of all charges, the right to confront accusers in court, which is very significant. You want to be able to meet your accusers face to face and actually ask them some questions. Right to produce supporting evidence or witness. So especially if you're a defendant, if the state has evidence that will work for you, you have the right to that evidence and the right to legal counsel. It's not just, juries are not just in the amendments. And this is one of those pieces where juries are so, so important. They weren't just in the Bill of Rights. They are baked into the Constitution. Article 3, Section 2 says the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. So that's in Article 3 of the Constitution. It's not a Bill of Rights, and it's a very big deal that it's in Article 3. Anybody know about Article 3 in the Constitution? Look at that smile on Gemma's face. Gemma, can you tell us what Article 3 is? Thank you, Star, for running all around, because we can also keep one going.
If I remember correctly,
Yeah.
is the article that deals with the judiciary.
It is, exactly. Thank you. So the Article 1 deals with Congress, Article 2 deals with the executive, Article 3 deals with the judiciary. Isn't that fascinating? It's not just about judges and the federal judicial system. Baked into it is that juries are key for this whole thing. And when Steve said earlier that why do we need juries to keep judges in their place, the whole design was to have juries as part of the whole deal. And this goes way, 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 way back. Very first mention of juries in terms of American legal documents is this document there, which you may recognize, signed on July 4th, 1776. And one of the key provisions, or one of the indictments, I want to say that, against King George was for depriving us of the benefits of a trial by jury. So that was actionable for those guys back in the day. They could justify having an armed rebellion against the king because he had denied to them the benefits of a trial by jury. And I don't want to go down too far this road, but it turns out another thing that was originally included in the Declaration of Independence, another part of the indictments against King George, for forcing the crime of slavery upon us. That was going to be part of the initial Declaration of Independence. Thomas Jefferson wrote it. It was probably the longest of all the little indictments that he includes. It's very badly written. He's trying to make sense of his life. You can just feel all the cognitive dissonance spilling off the page. Anyway, he brings it to all his fellow rebellion makers, and they go, "What are you, crazy? We can't say this." So they got knocked out. But this one stays in. It was clearly going to be a problem. So at the founding, we have Federalists and we have Anti-Federalists. And usually the Federalists were the ones who are very noble, and they have aspirations for creating an organization in which the elites are able to control. And then at the same time, we had Anti-Federalists, and they're much more the populists. Turns out, this is the only thing I have found in my 20 years of thinking about the Constitution where they actually agreed. And that was, Anti-Federalists love juries. Do I have an Anti-Federalist in the room? Oh, I think you're an Anti-Federalist, so would you read this one? And then I think I may have some other Anti-Federalists.
Wait, I got set up.
Yeah, you got set up.
So the jury is a democratic branch of the judiciary power, more necessary than representatives in the legislature.
Wow. So, more necessary than representatives in the legislature. That was somebody called the Maryland Farmer. And usually Federalists are like this when you have pictures of them. They're the ones like, you guys are just elites. You just want to control everything. I don't like that. And the Maryland Farmer is one. Who knows who he was? They oftentimes wrote things anonymously. Here's another anti-federalist. Charlie, do you want to read this one?
Judges, unencumbered by juries, have been ever found much better friends to government than to the people. Such judges will always be more desirable than juries to would-be tyrants.
Wow, now this is a little, what we might say, they are dissing judges here. Everybody see this? You want to make sure there are juries because judges, and maybe it's because they're elites, have a tendency to be in cahoots with the tyrants. So that's why we need juries.
Obviously, that was before Ruth Bader Ginsburg.
And that was, and before Jack Wesley. Before Ruth Bader Ginsburg and before Jack Wesley. And so you can imagine an anti-federalist saying, we got to watch out about the judges, and that's why we need juries. And this guy was called the Old Whig. I love their little names. But guess what? Federalists, they also love juries. And there's Alexander Hamilton. Do I have Alexander Hamilton?
The excellence of the trial by jury is that it is a security against corruption. Temptations to prostitution, which the judges might have to surmount, must certainly be much fewer.
Yeah, so Adam, what does that mean?
Kind of what Stephen was saying earlier, and he put it really well, is that, when you have the judges exposed to the daylight of the jury, it kind of makes it harder for them to be more in cahoots with a would-be tyrant.
Right, and so the Federalists don't say it this way, like the people need to stop the judges. The Federalists say it, human nature is such. If you have power, you will become corrupt. And so we're not going to make this any sort of class divide if you're a Federalist. You just say everybody is going to have this problem. And so the Federalist 83, Alexander Hamilton, he makes that case. Human beings in general, they will be corrupt if you give them that opportunity. So make sure there is a jury, because those temptations to prostitution, watch out. And what do they mean? To just engage in private interests at the expense of the state. But it turns out even judges love juries at this time. I tell you, 18th century, awesome time to be a juror. What is it? And could we pass that to our judge?
Is this on? Yeah.
Yeah.
Let him be considered as a criminal by the general government, yet only his fellow citizens can convict him. They are his jury, and if they pronounce him innocent, not all the powers of Congress can hurt him, and innocent they certainly will pronounce him if the supposed law he resisted was an act of usurpation.
So, not only are and this is Theophilus Parsons of 1780, who became, I think, a Supreme Court judge in the state of Massachusetts. This one is really interesting, because we are getting something different happening here. It's not just that the juries are there to stop those temptations to prostitution. Does anybody notice what this guy is saying jurors can do?
Ignore the law.
They can ignore the law. Whoa. This isn't just an OJ situation, right? This is like, if you feel the law is a supposed law was actually an act of usurpation of power, a jury can decide not to abide by the law. Kick-ass juries in the 18th century.
Not included in any of my standard instructions, I might add.
Really? You don't tell the jurors that this is their history, that they can ignore the law?
No, I don't tell them that that is the history. I don't have time to give them that deep a history lesson.
Got it.
I tell them that they actually are required to follow the law as the judge gives it to them.
Oh, yes, yeah.
Now, what's, of course, interesting, even in today's circumstances, is I don't have any right afterwards to poll them as to whether they followed my instructions or not once they get into the jury room.
Got it. So you give them the line. And for everybody, this is our Honorable Jack Wesley of the District Court and the Family Court. So many courts in Vermont. Has been a lawyer and then a judge in this area for a very, very long time.
Retired for 4 years, so slightly out of touch.
and still serving, I think, in district court 2 days a week is what the rumor is. But this idea that judges will tell jurors nowadays that these are the laws that you need to follow. But then jurors go off into their own little room, and if they say, wow, did you know what the history of the jury is in the United States? We actually have a whole lot more powers than Jack Wesley just let us know. So now we can take matters into our own hands and find our own decision. And this is called jury review. Yes, Steve?
And is it, if a jury acts against the law, is that not cause for another trial or an appeal or something?
If the jury were, okay, wait, it's so great. Did everybody hear the question? If a jury does not follow the law, is that grounds for an appeal or what?
So if we're talking about the criminal law, then here in Vermont and everywhere else as far as I know, if the jury acquits a criminal defendant, that's the last say. That there is no appeal from an acquittal. There's no right for the sitting judge to review it as potentially against the evidence or potentially against the law, and there's no right to take that verdict of acquittal to an appellate court.
Wow.
And the other
This is the important balance that the Constitution provides. If the state wins the verdict, the defendant has a constitutional right to review by appeal.
Oh, wow. Okay, great. I'm going to send out one more piece, and it's on this exact same notion, because we often talk about judicial review in the United States. The Supreme Court can review statutes to see if they're constitutional. That's been since Justice John Marshall established that doctrine. But it turns out there was an old doctrine called jury review, and maybe can we pass a mic to Charlie here, because this is an anti-federalist.
If judges tried to subvert the laws and change the forms of government, jurors would check them by deciding against their opinions and determinations.
Right. So another strong case, this guy called himself the Federalist Farmer, even though he was an anti-federalist. A big push that all these things that jurors can do in order to check judges, even by deciding against their opinions. Maybe even deciding against the judge's jury instructions? Could be. That's what they're starting to suggest back there in those old days. So this was the case in the beginning, in the 18th century, how we understood juries fitting into the overall system of American justice. And less than 100 years later, about 1830, I have it written down somewhere, 1835, Alexis de Tocqueville comes to the United States. He's a young man. He has come to see what the prison reform movement looks like in the United States. And he's very interested in what's going on in this new democracy. And he's an aristocrat, so he's a little bit worried, because what's all this equality? I mean, how is this going to work out? Because if you just make everybody equal, then probably they'll just all want things for themselves. They'll become very ruthless. They might be totally commercial. Nowadays we might say, oh my God, it's neoliberalism. But Tocqueville said this is what's going to happen if everybody is just on the same playing field and they're competing with each other. However, he found two institutions, or two influences, maybe that's a better word, that would save Americans from just vulgar capitalism. And that was the jury. So do we have Tocqueville in the room? I believe, Charlie, can you pass it right behind you? I think I found a European visitor who might be able to help us with this.
The jury is a gratuitous public school where every juror learns his rights, enters into daily communication with the most learned and enlightened members of the upper classes, and becomes practically acquainted with the laws.
Yes, Sharon. This is exactly what Sharon said. Same thing that Tocqueville said. Sharon mentioned how when you go into the courtroom, you get to see how the defendant is treated. You get to see this knowledge of how it really works. And it really works because you begin to understand all these details. So as far as Tocqueville was concerned, this was the greatest thing in the world. It was going to save us from being totally self-centered. Tocqueville.
The institution of the jury raises the people itself to the bench of judges. The jury teaches every man not to recoil before the responsibility of his own actions, and impresses him with that manly confidence without which no political virtue can exist. By obliging men to turn their attention to other affairs than their own, it rubs off that private selfishness which is the rust of society.
So we get this idea that a juror can be as high as a judge. Now all this stuff about manliness is important because there was a second influence that Tocqueville thought would save America from vulgar capitalism. And that was women. Because women were the moral leaders in their family. They educated their children. Unlike the aristocrats in Europe, where they would hire nannies, Tocqueville saw women having a moderating influence on just pure greed. So jurors became more like women, right? They had confidence, and it rubbed off that private selfishness. So he was completely convinced that the whole thing was going to work. Democracy could work in America as long as there were women and as long as there were jurors. So we're in pretty good shape, right? Yes.
And were there women on the jury?
And so were there women on the jury? We get a lot of head shaking. Right? No, not at that time. Right. We're about to reach the 100th anniversary of the 19th Amendment, in which women get the suffrage. We have to wait a few more months. When we hit 2020, it'll be the 100-year anniversary. And at that point, you can start to see that slowly starting to happen. Okay. So what happens is, for a long time, we have a system where the juries are revered, where they're considered very, very important, and then things start to change. The first thing that's very important, and constitutional law is bizarre, because you have to keep two systems in mind at the same time. And as people remember from these early amendments, it's Congress shall make no law. So all of this doesn't apply to the states, right? If it's the Bill of Rights, and it's just Congress shall make no law, then the only system that is really important about the juries is the federal system. However, we did see with Article 3 that the states have to have juries. So it's interesting in the sense of juries have gotten, or states have had to recognize juries sooner than, at least by the language of the law, than actually happened. That's what I'm trying to tell you. I'm trying to say that the law was all about juries, 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 but it turns out the states always said, the Bill of Rights do not apply to us. And this was particularly true leading up to the Civil War and then during Reconstruction. How do you make the states conform? The trick that lawyers used was the 14th Amendment. And even though the 14th Amendment was passed 1868, is it? 67, right after the Civil War, it took until the 20th century for some of these liberties in the Bill of Rights to actually be applied to the states. So I want to just show you what the time period is for the Sixth Amendment, some of those clauses. Right to a fair trial didn't actually come about until 1932, in terms of states having to provide that right. 1963, right to counsel in felony cases. Even though it was in the Sixth Amendment for a long time. 1965, right to confront opposing witnesses. Yes, Jack Leslie.
And so, when you say it didn't really come about, it eventually came about, right, because there was a case before the United States Supreme Court that said the 14th Amendment guarantees these rights even in the states.
Exactly, that's it. Thank you for that clarification. That's why people want to go all the way to the Supreme Court, because a lot of these cases, they're trying to expand the liberties and make it so that the states have to recognize these liberties as well. 1966 is the right to an impartial jury. Is that the right to a jury? No. It's just the right to an impartial jury. Doesn't mean you still have so 1966, you still don't have a right to a jury. Because it's just you get the right to an impartial jury if you have a jury. Now, it's kind of interesting around that capital punishment that Steve was talking about. An impartial jury, does that mean everybody's impartial to the death penalty? No, it turns out there's ways to make sure that your jury is going to fulfill certain statutory obligations. But this right, as defined by the Supreme Court, comes up in 66. And then in 1967, you have the right to a speedy trial. So you see how it takes specific cases and then little bits of the Bill of Rights actually stick to the states. Just because we talked about it. Does anybody know when the Second Amendment was incorporated? Gemma does. Yes, Gemma, what was the year?
2008.
2008 is the Heller one. So
2010.
2010. Exactly, McDonald decision. So the Second Amendment, which just applied to the federal government, which meant that Congress could make no law to a certain degree that bridged the right to bear arms, that was incorporated in 2010. It became a fundamental right based on a decision in Chicago, and it was Justice Alito who said it's a fundamental right. So for people who are hoping to scale back on gun laws, that was a hard decision, because then all of a sudden the states have to recognize the Second Amendment. And for people who want their Second Amendment protected, that was a great decision, because now all of a sudden it sticks. So that's how incorporation worked. We had the words on the paper, it means the Congress, and then all of a sudden they throw a little dart and it sticks in the states, and all the states have to recognize it. Gemma.
I just have to say that's probably a really, really bad example for incorporation, though, because ever since McDonald, the Supreme Court has absolutely refused to take any other cases. And
on the Second Amendment?
On the Second Amendment,
yes.
And the interesting thing about that is that one of the main reasons why, thank you, why the Supreme Court would grant certiorari to a case like that would be is if there is a circuit split. If one of the appellate courts in one circuit ruled differently than a different circuit. And it turns out that that's probably never actually going to be the case because of the makeup of the United States. In general, the more rural districts are not going to pass any gun control laws that would ever be challenged in those states, so a circuit split's never going to come up.
So the conflict of law that sometimes you need in order to revisit this again may not happen.
So with the Fourth Circuit in Maryland, with the assault weapons ban there, it's, the Supreme Court just completely refused to take the case, and so it's probably never going to be heard because Wyoming is not going to pass an assault weapons ban, and then we would have a circuit split.
And this is the fun thing about understanding constitutional law. You begin to understand all these little paths that maybe you could go down this way, maybe you could go down that way. So we're looking, though, for the right to a jury. Because here we have all these different incorporations, and we still don't have the actual right to a jury that's going to apply to the states. And it takes a case in 1968, which is known as Duncan v. Louisiana. Those are the men who were on the Supreme Court at the time. It's a washed out picture, so it makes it look like it's a bunch of white guys. It's not a bunch of white guys, right? Who's the other who's the justice who's there? Who's the, there was the African American seat.
Right.
Thurgood Marshall, exactly. So this case takes place in Plaquemines Parish, Louisiana, and it was under an order to integrate its schools. And as part of that, there was a certain amount of controversy about black kids and white kids being in the same high school. So a man named Gary Duncan, he was 19 years old, he was driving down the street, he goes near where the high school is, and he sees a bunch of white guys beating up on his cousins. So he says, I'm going to stop and help them out. He stops the car, he opens the door, he says, come on in, we're going to get out of here. And in that escape, Gary Duncan allegedly hits the elbow of one of the white guys. So he is charged with assault and goes in front of a judge, and the judge requires him to spend 2 months in jail and pay $150. And Gary Duncan says, whoa, 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 whoa. You can't make that decision just in front of a judge. I have a right to a jury. And this goes to the Supreme Court. So here is Duncan's argument.
In our democratic society, trial by jury provides both symbolic expression and indispensable practical protection to the concept that the decision to adjudge a citizen, a criminal, and to deprive him of his liberty is too important to be committed to professional administrators alone.
Yeah, professional administrators is not good enough for this kind of a circumstance. They're talking about judges or magistrate or something of that sort.
Community participation has become a vital balance wheel in the administration of American criminal justice, protecting accused persons from judicial arbitrariness or discrimination.
Yeah, so this goes back to Steve's point, keep judges in their place. We need to have this balance. So there's Duncan's argument. But Louisiana has an argument. Let's hear what that one is.
Louisiana's law derives from French and Spanish sources, neither of which required a trial by jury. The right to a jury trial was not fundamental and so should not be incorporated.
Hey, which, that's true about Louisiana. It comes out of a totally different tradition. And so is it really fundamental? They've been getting along just fine without juries. So, and when you see that word fundamental, that's what they're looking for. Because if it's fundamental to the American scheme of justice or part of the order of liberties, that means it needs to be applied to the states. And Louisiana says, no, 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 no. You don't get to do that. I think that Louisiana has another argument as well.
The jury, for the most part, is more guilty of obvious partiality than the judge and the public prosecutor.
Whoa, look at that. We already heard this one. Eric said that one. Jurors are compromised. There's a rural bias. No, racial bias. Can't read mine. Racial bias could be a rural bias, gender bias, class bias. Jurors are no better than judges. In fact, that's a quotation. And I kind of love this, like when they go to a text that's not prior case law. They went to Gunnar Myrdal's An American Dilemma, which is, you can't read the subtitle, The Negro Problem in Modern Democracy. This is a book that was published in 1944. Another foreign visitor comes to the United States, looks at race relations in the United States and says, this is a serious problem. And it's not just that you have the Ku Klux Klan and other white supremacy groups. It is a problem within the system. So they do this intensive social science research. Besides Gunnar Myrdal, he was also Myrtle. He was informed by somebody, Ralph Bunchy, maybe you all know him, Ralph Bunch, first African American to get a Nobel Prize. He was a political scientist, so they rely heavily on Mr. Bunch's data and analysis to create this book. And then Louisiana uses this to make their case that you do not want to rely on jurors because they are as compromised as anybody else in this system. So, drumbeat, the court's decision. Anybody know where they go? Where do you think this one's going to go? Are we going to get a right to a jury? Where's the judges? Are they going to take the jury down? Anybody want to hazard a guess? Jury? Yeah, Jane, what do you think happens?
The jury has lasted, and it's the most effective way of getting a cross-section of opinion and so forth.
Right.
Than a judge.
So you think Byron White's going to go with the jury? We'll find out. I won't ask you. It is versus Louisiana. What do you think then, Judy?
I think Louisiana's going to stay the way just they are.
And Judy thinks Louisiana's going to stay just the way they are. Okay, so we've got 1-on-1. And drumbeat, Byron White, could we get the reading?
So it's important to recognize at this point that Justice White was also known as Justice Whizzer White, because he was actually a great football star in college before he got to the Supreme Court.
Right.
And you got to say that this was a touchdown play that he runs here.
All right. The quarterback, Whizzer, okay.
Maybe a scat back. Trial by jury in criminal cases is fundamental to the American scheme of justice.
And this is that term I said you always want to look for that. That means bing, incorporation is going to work.
Mr. Hamilton disagrees. Providing an accused with the right to be tried by a jury of his peers gave him an inestimable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge.
Right. So there we have it. The Supreme Court goes with the jury, just as Jane thought. Yes, it's fundamental. But there was a dissent, and we can pass it right over the aisle to our dissenters. This is Justice Harlan and Potter.
Untrained jurors are presumably less adept at reaching accurate conclusions of fact than judges, particularly if the issues are many or complex.
So we heard that one before too. That's what Eric said earlier. Sometimes jurors just can't stay on top of this. This is a changing world, people. They use all sorts of new technology. All sorts of new ideas are coming out. Complex criminal requirements. It's too much for a jury. You have to have a judge. Yes?
Just a point for local interest. The other dissenting justice was not named Potter. He was named Potter Stewart, father of our local lawyer, Potter Stewart Jr.
Right. Yes, we do have a local connection here. I keep thinking, like, I'm going to call up Potter Stewart and say, you want to come to one of these debating our rights? I want you to read your dad's dissents. And I thought, oh, that may be pushing it a little bit more. So we have, Sheldon, you wanted to say something. Do we have a mic for Sheldon? And then we're going to go back to, Casey, you should hold on to it because you have more words.
I was wondering how then the right to reject both a judge and a jury because they will be biased allows a lawyer for a defendant to have the court case removed from one locale to another. When did that come in?
So when is it that a defense attorney makes the determination that both the judge and the jury are all too biased, when they can make that request to move to a different location? And that would be just the sort of conditions that would make somebody want to make that request. Yeah. So I want to hear a little bit more for what the dissent says because they have another reason.
The jury system is a cumbersome process, not only imposing great cost in time and money on both the state and the jurors themselves, but also contributing to delay in the machinery of justice.
Right. So those are the two arguments against the jury being the fundamental scheme of justice. And at this time in 1968, I wish I could tell you most of the cases were going to criminal trial. And that most of the cases were being heard by jurors. That's a hard word to say, isn't it? Rural juror. Very hard thing to say. Juries. However, by 1962, juries tried 8.2% of criminal cases in federal court. That's in 62. By 2013, juries tried 3.6%. That's not much in the federal system. In 1976, the courts in the most populous states tried 1.8% of criminal cases. By 2013, it had dropped to 0.6%. So even when this case happened, Duncan v. Louisiana, and you could say, wow, Jane won, and Judy's idea about Louisiana lost. From a practical standpoint, there were hardly any jury trials. In the federal, and even worse in the states. 0.3% of all criminal cases go to jury trials in the states. Despite what Sharon was saying, how lovely it was to serve on the jury, how you began to learn the whole system. We also had other people talking about don't abdicate responsibility, and that it's an affirming process. People are not getting that. And you can say, so why is that? Well, there's one big example. It's 2 words. Plea bargaining. Between 90 and 95% of all cases in the federal and state criminal justice systems are handled through plea deals. So that's how most of our criminal justice happens right now. Should be, it's a high holy day, Yom Kippur. I feel like, Day of Atonement. That's a pretty sad statistic. And why is that? Because people are rational. If you cop a plea for a drug charge, now this is from 2012, you will likely serve 5 years, 4 months, which a great proportion of the population did. If you risk going to a trial, you could easily serve 16 years, same crime, very different sentence. So it's in your best interest to cop a deal rather than risk going in front of a jury. But there's another reason beside plea deals, and I'm really glad that tonight there's people here who work in the community justice system, and there's also something called diversion courts. So here's a picture. This is so complicated. Here's the state of Vermont. These are the many, many pathways to justice. It's not complete. In fact, I bet Jackie notices there's something missing. We can talk about why. So if you see in the upper left-hand corner, if there's an incident and then the first place is law enforcement, an arresting officer may say, all right, this can go to diversion, pre-charge diversion. And they call that a pre-charge program. Maybe I shouldn't call it diversion because that's going to mean something else. A pre-charge program, which means the person does not even go to court, they go somewhere else, and then something gets worked out. If you go to court, then you look at all these pathways you have. This is for juveniles, so a juvenile could end up in family division if they file a motion, or they can go to criminal division. State's attorneys will also refer people to something called court diversion. If it has to do with traffic, drunk driving, they'll send you sometimes to civil court. And then the other one down here is teen alcohol safety. Yeah. Jackie, do you notice what's not on the...
Restorative justice?
There's no rep panels, reparative panels. A reparative panel would come from the state's attorney's office, or maybe from an arresting officer.
State's attorney, it'll come from court.
It'll come from court. And it's funny that this is a Vermont pathways, and they don't include that. Do rep panels see people between the ages of 10 and 17? No. Mm-hmm. So that's why it's not on this, because this just shows you what juveniles. A lot of choices here, right? A little confusing, maybe, but you got a lot of pathways to justice in Vermont. So where is the jury? Where does the jury live here, people? Do we see any place for a jury in this whole system? Criminal division, right there. I wonder if I have a little, look, does that work? Oh, there it is. Sorry, my hand's shaking. I don't mean to give you motion sickness. That's the only place in that entire chart where you can see a jury. It's just not there. So the state, for very good intentions, believe me, I'm not saying that everybody should go to criminal court, but isn't it interesting how we've just wiped out the jury in this complex system? A court diversion in Burlington, Vermont, a person is referred to diversion. There's certain criteria. You choose whether to participate or not. So participation is voluntary. You admit responsibility for your actions. You don't go in front of a judge and have a defense attorney explain the situation. You meet with a board of community volunteers and completes a contract designed to repair the harm done to the victim and the larger community and address underlying factors in the individual's life that contributed to the crime. So this is, and I just got this off the website in Vermont diversion programs. You also then pay a fee, and if you resolve the issue, you sign a contract and your charges are expunged. So it's kind of like a jury. What? Yeah?
So just to be a little bit clear here, most diversion referrals, and I think someone maybe who is part of the restorative justice system here mentioned this, most diversion referrals actually do involve, they happen at arraignment in most cases involving criminal charges. And so they often do involve the right to have the advice of a lawyer at that time. They usually involve actually coming before the judge at arraignment, who is then notified by the state's attorney that the state is recommending this case for diversion. And then, depends on the judge, but when I was doing this, I would usually explain a little bit about what's up on the board now, about what the diversion system is, mostly in terms of encouragement and emphasizing that this is a way to possibly not be back in court at all and have your case expunged.
Yeah. So
I just want to correct perhaps the misapprehension that the court is never involved in diversion referrals.
Right, and so, and thank you, because it is very clear that the court is involved in diversion. What do you think about the jury, though? Do they get involved in diversion?
No, these diversion referrals are a long way down, ahead of the road that might eventually lead to a jury trial. I mean, for example, if someone does not complete their diversion contract and then is back before the court to begin the process again, by the way, with the whole complement of due process rights, including the presumption of innocence. So at that point, you may be marching down the road toward a possible jury trial with a lot of plea bargaining possibilities in between.
Great, okay, so it sounds like I want to go back to this, because even though this may look, that trial that I point to when they get all this, it doesn't take up much space. What we're hearing is somebody could go through diversion and then it doesn't work out and then they could go to trial. And for purposes of tonight's discussion, I'm really trying to figure out where does the jury fit in all this. Because the jury is supposed to do certain things in order, it's civic education, you learn your rights, you find out how lawyers work, you figure out how the whole judicial system works. So there's certain things that juries can do, and then if we don't have that happening, that certain element gets wiped out. That's the Sixth Amendment part of the jury becomes extinct. So I wanted to draw a picture. This is a picture that I got off a website from a diversion program in California. And there's an argument that could be made that maybe we don't need juries anymore. And I'm willing to hear that. Because this is another way this is volunteers in a community to understand how the criminal justice system works. And anybody who served on any sort of reparative panel or in a circle of support and accountability, you begin to understand how the judicial system works. But I guess I would want to say, is it a slightly different education? And I'm going to open this up to conversations. I just have a few more slides to show people, and then I'm really curious what you all, because I'm throwing some rather big ideas out here. There was a book that just came out 2013 called The Missing American Jury. So those statistics that I got about how 0.3% of state criminal cases actually go to jury trial, I got from this book. And this is law professor Suja Thomas, and she says, like Tocqueville, like Byron White, like so many people, those Federalists and those Anti-Federalists, those 18th century thinkers, the jury can perform important functions, including involving people in the operation of government on a more regular basis, thus engaging them in appreciating and policing the government. And that's what we keep getting with the juror. They act a little bit like a police that also can appreciate when it works. Who kidnapped the jury? According to Suja Thomas, it was Congress, it was state governments, and the Supreme Court who have seized the domain of the jury. Set up systems so that we don't need jurors anymore. The jury should be recognized as a co-equal. This is a fairly radical idea, to bring back the idea that the jurors are co-equal of the traditional actors, and specifically as a significant check to balance their powers. Maybe totally unrealistic in the 21st century. This is what her argument is. So I wanted to just sort of throw out a few questions, which is one, do we still need juries? And you can tell me, no, we don't. And I will be very open to that. Or you can tell me they're really, really important, because that's how people really learn how the system works, and they can police the system from the inside. If we don't have juries and we have these alternative forms of justice, how do we police them? And I'm for a lot of these alternatives, but I'm also somebody who always wants to know, how are the volunteers or the members of the public knowledgeable enough that they can start to ask bigger questions around these liberties? And finally, without juries, how else do we build an educated citizenry? So, any thoughts, wonderments? Yes, Steve.
I think we find ourselves in a situation where the history has kind of been replaced by a criminal industrial complex. That in fact the demands of the, this is not to say that you're a part of the criminal industrial complex, please no. But basically on a larger scale, so many people are processed in the system, plea bargain, private prisons, I mean, some of my own research, prisons were a major source of blood plasma. You know, there are all kinds of industries and so on and so forth. So the question is a whole other element of the fact that the people who are going to the system are cogs. I mean, they're products. The prisoner is a product. You know, it's a manufactured kind of system rather than a system of justice. And of course, we'd like to get away from that. But, you know, where the jury fits into that, well, I would say that they should fit writ large. But in fact, you know, when you have onerous sentencing in the United States, the sentencing is often well beyond what it is in other countries. And the poor individual says, I know I didn't do it. Or there's some, you know, exculpatory circumstances. But to face 16 years when I can face 5, and also there's a heavy, heavy racial component which pervades the system, because you know black people are used as labor, black people are used as the profit-making items that go through the system and so on. So it's a very complicated and ugly and mushy situation.
So do you think juries could help this at all?
It could help if, in fact, the juries were represented. Part of the thing is, I mean, where you have juries really being representative of the community, and so basically racial bias in the juries, so on and so forth. It could help it. I think the process itself, though, has to be rethought. I think sentencing has to be reduced in the first place. I think there has to be a way of putting some humanity back in the system as well, and that's revolutionary, really.
Right.
Yeah.
Yeah, revolutionary. Yeah, other thoughts? Steve, and then Gemma.
I'm afraid this is a monkey wrench, but my personal opinion is that that what needs questioning here is the idea of justice. That I think that you're right. There's a moment that the moment in your lecture that was very telling was the slide about plea bargaining. But if the whole idea is that if something bad in the world happens, what needs to happen is justice, I think that's already a problem. And that partly it's dealt with ideas of restorative justice, for instance, which are
not about justice per se. They're really changing the meaning of the word justice. Justice, since Greek times, is a state form of retribution. The idea being that if something bad happens, punishment should follow. And I think that without questioning that, the other questions are actually not thoroughly examined.
Okay. Gemma.
There's just a couple of things that I wanted to point out about the Sixth Amendment. And the first one is that it only applies to criminal proceedings. None of the guarantees of the Sixth Amendment apply to civil proceedings.
That'll be January when we do the Seventh Amendment. Right. We've had two people say the entire system is so flawed that trying to retrieve it through juries is not going to work. Right.
And on that subject,
yes,
one thing that I think is probably not obvious to most people is that there are no juries at the appellate level.
And why is that important?
That is probably something that you could explain better, Judge Wesley.
To tell you the truth, I've never thought of it in that fashion. Although, you know, most trials at the trial level are presided over by single jurists, whereas most appellate panels are made up of more than one person, and you could analogize appellate panels to a jury. But I think probably, and I certainly couldn't quote the case, but the constitutional right to a trial by a jury of one's peers applies at the first level of charge. And I don't think there's ever been recognized a constitutional right to have a jury of one's peers at the appellate level.
Right.
But I've never studied it much.
Right, and if you're interested in this question, like how is it that so much of the judicial system, especially since we have this Article 3, that, yeah, certainly a criminal trial, that's your first level into the machinery, but there's this idea that juries are central. And how is it that so many parts of the apparatus, jurors don't even appear? This is her argument, that, and she'll take you through the different changes in administrative law in which jurors became less and less important. So it's one of those strange things in the United States. We oftentimes tell the story that we get more rights as we go along, and some of that is absolutely right around the Civil Rights Act and the expansion of rights for more and more people. And then we have this other thing where the rights have actually gotten less and less and less. And people seem to be like, okay, that's all right. We're just going to have the professionals do it. You know, no disrespect to the professionals, but we stopped feeling that our judicial system is dependent on jurors more than representatives in Congress. That was an old idea. Casey, and then we'll go to Sheldon.
This isn't really a fully worked out thought, and I don't have the statistics on hand, but I was interested in you suggested there's a statistical decline in the actual amount of jury trials since the incorporation decisions in the 1960s.
They only started keeping records on trials, I think, starting in 61, 62 in the federal system.
Yeah.
So before that, there was no information.
Right.
But what did I say? In
From 3% to
yeah, it was
0.3.
it was still low. Yeah.
But I was also thinking about also the increase, like the statistical increase in incarceration rates, going back to this point, at least since especially since Nixon's declaration of the war on drugs, and the increase in criminal offenses. And I'm interested in this idea of like juries potentially introducing a humanizing element to the jury system, and whether that trial by jury has become incompatible with a bureaucratic system of justice that is increasing penalization and increasing incarceration, and it's much financially easier to bypass the jury and to just go through a plea-based system.
Right, and that's one of the big arguments. Go ahead. And
that just last point. Then maybe the introduction of a jury system, or taking it seriously as a civic duty and a civic right, could be a way of countering an incarceration state. So that's all I have.
Thank you, Casey. That's this argument that's out there. If you want to reduce the prison industrial complex, then instead of passing it on to the administrative state, you take back certain constitutional rights, right? You don't have to make up these rights. These rights are baked into the Constitution. It's just people saying, we take that so seriously, we want to make sure that when you go forward, you actually have a jury. It may sound very idealistic, but it's a totally different way of framing the problem and getting people involved. There's a lot of people who, with precarious labor, seem to have more time on their hands. And there's a little bit of money in sitting in on a jury. I just feel like this could be an element where people could be like, let's put more people on jury, slow down the system a little bit. Maybe think, wow, that's a pretty crazy charge. I don't feel good about that charge. Sheldon.
Another place where there's no judge or no jury is where Trump has started making accusations, and that is treason. And what it says is Congress shall have the power to declare the punishment for treason.
Right. And so, that's not a criminal case. It doesn't have the Sixth Amendment protections. However, and Sheldon, you want to make a larger point, is my guess.
Well, how can Trump call people treasonous now? What does it mean, the word mean to him?
I don't know. Yeah, right. I mean, it's an accusation that one of the reasons people get nervous with the kind of rhetoric that we have nowadays is that language is being used that is beyond what any criminal court can deal with. And at that point, what do you do to try and I hear Steve's point about justice. Steve and I will disagree about this a lot. That we need to get back to the basics and understanding pain and how to respond to pain. I completely agree in our conversations we've had about that. But we also have a legal system that's designed to try and come up with forms of justice that involve people, regular citizens, not just professionals. And this system, the criminal justice system, has been way too many cases thrown at it, which we've heard from a number of people here, and the resources that are actually the democratic resources have been ignored willingly. And this is why I wanted this here, by design. Willingly by the part of citizens and by design by Congress and administrators. Usually not because of evil intent, I'm not going to say that, but because of these efforts to be more expeditious, to not ask jurors to deal with complicated legal questions, all sorts of reasons. We've backed away from jurors. It really shows, in my mind, a lack of trust in ourselves. We do not trust a constitutional democracy. If we did, we'd be running around and asking for jury trials. Yeah, Eric, and we'll start to wrap this up. So if you have a question, raise your hand. We'll make sure. Is that Mimi over there? Mimi, I'd be so curious what you think about this. Yes, Eric, and then to Sharon, and then we'll get it to Mimi.
Well, I think if we uphold the idea of a jury system as being integral to our like basic sense of like, I think if we want to place reforms upon the system, I think a lot of it starts with trying to have a better educated populace on just certain aspects of certainly of the law, but like I think just thinking of your last talk and thinking of when we were mentioning Ava DuVernay's documentary When They See Us, or series When They See Us, just having like an understanding of false confessions. Like I think for many prosecutors, like bringing a confession to trial is like a surefire way of just having juries be able to swing to their side, and certain kinds of forensic evidence, fingerprint evidence, blood evidence, trace evidence. It's just imperative that we have a populace that has a greater understanding of like the precarious nature, and the that it's not, nothing's 100%, nothing's really sure. So
cool. And I'm glad that Sharon had her hand up, because Sharon is talking about the education you can get. Eric is saying people need to understand how they can be manipulated by prosecutors. If you're going to serve on a jury, you want to understand how you're going to be manipulated. And Sharon was talking about, so I'm so glad you raised your hand, Sharon.
My question was going to be, how do grand juries fit into this?
Right. Which shows up is, I think, a Fifth Amendment protection. All of a sudden now I believe that that's a right in the Fifth Amendment. In order for a prosecutor, for the state to deliver a charge, there needs to be a grand jury, which means there's an element of people, ordinary people, making sure that the prosecutor has enough evidence to file the charge. Jack Wesley would help me out here.
Well, not very much, other than I infer by the fact that there is no constitutionally recognized right for a defendant to have charges brought here in this state by a grand jury, that the grand jury right in the Fifth Amendment may still be one of those rights that has not been required of the states by the 14th Amendment.
Right, but I think that's true. I don't know if anybody else has that detail. I think the right to a grand jury is on the federal level and not on the state level. Yeah. Can I put you on the spot? We have our public defender here. Do we have yeah.
Hi. So, it is really interesting because when you raise grand juries, I think that is important because a grand jury is like, I don't know the number, 30, 40 people, and they may indict. It's not they must indict, whereas an instruction to a petite jury, or the jury that we normally know, is if you find these certain things, you must convict. It's not you may, it's you must. Now, it's true that juries can rebel and say, despite the law, we're going to say not guilty. But even, I can't argue that. If I argued that, I could be held in contempt by Judge Wesley. Because I'm not allowed to say, ignore the law, do justice here. I can't do that. So it's really interesting. I think the grand jury, it's a shame that we don't use it more. We use it, I think, in big cases. It's kind of very secret here. But I have worked in other states where the grand jury is required for felony offenses. And it's really interesting. And I've practiced in the grand jury. And you can actually say to the grand jury, like, well, a grand jury can say, we're just not going to do this. This is just wrong.
Yeah.
So it's interesting.
So that's a place where those larger questions that the two Steves are wanting us to think about, the larger questions. When do people get to say, wait a minute, what's justice around? What's really happening? And a grand jury, which is not required in the state of Vermont, but in other states it is one of those places where ordinary people can say, whoa, 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 what do you think you're doing? Yeah. Any other questions or comments? Well, yes, Sharon.
Just follow up a little bit on why I think that experience of being on a jury is so important. And I think it starts in the courtroom with the judges talking to the jurors and telling them how important it is. And I was so impressed with people. It's like they just changed when they got in that room. And they took this so seriously. They realized that this person's future was in their hands. And when they didn't understand something, we sent notes out asking questions. We don't get this, or what does this mean? And I just, it was several of the most valuable experiences, and just gave me such confidence in what people can do when they go in with the right attitude and wanting to do something right.
And your word confidence feels so important, that you gained confidence in our democracy by doing this.
Absolutely.
Yeah. Awesome. Charlie.
Sorry. So we know that the percentage of trials that are done by jury is decreasing. But is that because less are going to jury, or is that because there are more criminal cases, and the same number is going to trial by jury.
Oh, so because we're dealing in percentages.
Right.
So there may be this whole, like a fire hose of cases. And somebody mentioned the war on drugs. So we saw, there's many places where there seems to be a lot of people are being charged with a lot of crimes. So there's that element. And I don't have the hard numbers to see what it is, but this, obviously I'm making a big deal about this book. The circumstances are such that it's at risk of just disappearing. So anyway. Well, thank you so much for coming out of a Wednesday evening and for participating in this. And we'll be taking a break, and then we're going to go to civil juries with the 7th Amendment in January. Yeah, so thank you.